So what's the deal with this $100,000 fee for H1B petitions and this new H1B proclamation that was recently issued by the government? In this video, I'm going to go over the proclamation, explain what it actually says, who it applies to, who may be exempted from it, and I'm going to try to offer some practical considerations and tips on how to navigate this for anyone in H1B status now or anyone looking to apply for an H1B in the future. I know there's a lot of confusion about this. There's so much noise, and of course it's extremely scary for those who are looking to obtain H1B status. First and foremost, welcome back to the channel. My name is Adrian Pandev. I'm an attorney who helps foreign nationals navigate the United States legal system. My goal with these videos is to help explain some of these complicated processes and hopefully make them a little bit easier to navigate on the viewer's end. That being said, I also want to say thank you to all of you, that like these videos, follow the channel, subscribe, etc. It's been super meaningful. It means a lot to receive all this positive feedback from all of you. This has been a very new thing for me. So before I jump into the topic here, I just want to say a massive thank you to all of you who've done that. And if you like the channel, please follow and subscribe to it and like the video. Thank you in advance. Now, that being said, let's jump right into the main topic of today, right, which is this new H1B proclamation. So the first thing I want to say is that this is a highly dynamic area. I'm expecting litigation. I'm expecting challenges to this proclamation. So essentially, where the guidance and rules stand today could change in the future. And what I will do is, as any changes happen, I will record subsequent videos that will hopefully help clarify all of this. But I'm just noting this, that if you're watching this video many months after I recorded it, please make sure to check whether there's follow-up videos to this one so that you're getting the most up-to-date information. I'm recording this video in October of 2025, and that is what the information is essentially based off of. Now, that being said, let's get right into what happened. So what happened was on September 19, 2025, the government issued a proclamation stating that any H1B petition filed after September 21st of 2025 will have to pay a $100,000 fee with the petition. Obviously, that's a tremendous increase. H1B petitions do require fees. They often exceed several $1,000s if you include the premium processing fee, but it's never been $100,000. It is an insane increase. Now, that initial proclamation was very broad. It essentially said petitions filed on or after the 21st of September have to attach the $100,000 payment, and then in some cases there may be national interest exceptions. Now, what happened thereafter, government agencies, and this is Department of Homeland Security, so Customs and Border Protection, CBP, USCIS, Department of State, even the White House issued guidance on who this proclamation actually applies to. Now, this in and of itself is a bit unusual because usually in the text of the proclamation, you're going to have the exceptions so that the agencies don't have to essentially interpret super broad proclamations. So this was unusual. But where we find ourselves today is that the agencies have clarified that this new $100,000 fee will apply only to new H1B petitions for individuals, filed for individuals who are outside the US. So just let me repeat this really quick. New H1B petitions for individuals outside the US. So what does this mean? Well, it means that any extension of status petitions, any change of employer petitions, any amendment petitions will be not subject to this because those individuals are already in H1B status. They're not new H1B petitions. In addition to that, anyone that already has an H1B visa, right, like a valid H1B visa, so even if you're outside the US, but you had a valid H1B visa prior to September 21st, you're exempted from this proclamation based on the agency guidance. Where there was a lot of confusion was change of status petitions for individuals inside the US. So essentially individuals who are in another status right now, think of, I don't know, J1, F1, etc., who are filing a change of status petition or have filed a change of status petition, whether they will be impacted. Now, based on the agency guidance, as of this moment, change of status petitions should not be impacted as long as the individual is in the US and doing that change of status. So where that leaves us, essentially, is anyone for whom a petition was filed after September 21st, so just to make this clear, right, the petition has to be filed after September 21st, on or after. So any petition filed on September 20th or earlier was automatically exempt from this. So anyone whose petition was filed on September 21st or thereafter, who's outside the US, and for whom this is a new H1B petition, so essentially we're not talking about extensions filed and then the individual departed after the approval, etc. We're talking about new H1B petitions filed for individuals outside the US after September 21st. That's to whom it applies. So based on the guidance for these petitions, you have to attach a $100,000 check. Now, we'll talk more about the payment in a second. One surprising group of cases that was left out of this guidance were Cap-Exempt cases. So Cap-Exempt cases are those H1Bs that do not have to go through the H1B lottery because they're filed by a nonprofit affiliated with a college or university, or colleges and universities. And essentially, a lot of hospitals, a lot of educational institutions, schools, etc., will fall into this cap-exempt status. And there is no guidance on cap-exempt petitions. So essentially, the way the rule reads today is that cap-exempt petitions are subject to it. So new cap-exempt petitions filed after September 21st for individuals outside the US who are applying for a new H1B visa will be subject to it unless the individual can qualify for a national interest exception. So what is this national interest exemption? Well, what it means is that if the H1B petitioning organization can prove that the H1B worker's job duties and position in the US will benefit the United States national interest, then this $100,000 fee can be waived on a case-by-case basis. So while this is great news, unfortunately, the government has provided us no guidance on the procedures to apply for it. So essentially, how to apply for a national interest exemption, which agency to file it with. Do you include it with the USCIS petition, or is it something you file at the consular level when you apply for an H1B visa? We don't know. On top of that, there's been no guidance on what the required evidence will be and how the government will determine who qualifies for it. So essentially, we don't know how to apply for a national interest exemption and who will be qualified to receive one at this point in time. On top of this, what concerns me a lot is that last time we applied for national interest exemptions regularly was during the height of the COVID pandemic. And during that time, the different consular posts issuing the visas and the different officers applied these standards incredibly inconsistently. So essentially, you could have two individuals, essentially same facts, and one received the visa and one didn't receive the visa simply because a different consular post or officer looked at it. So my concern is that even if we receive guidance, there may be a lot of inconsistency in the application of these national interest exemptions. I will do my best to record more videos and provide more, clarifications as we receive more guidance. At this point in time, I think the key takeaway is that there is a national interest exemption. I think a lot of organizations, especially cap-exempt ones, but also companies working on important projects that will benefit the U.S. national interest, will be making these arguments. But at this point, there's zero guidance on how to apply and how these will be adjudicated. So I will do my best to provide more information on them. So this leads me to another issue, that the government has provided no guidance or mechanism on how to actually pay this $100,000 fee. So even for organizations who are going to be filing a new petition, who are willing to pay this $100,000 fee, there's no guidance on how to actually pay it, because as of this moment, USCIS's fee schedules, etc., are not updated. So I've actually heard reports from colleagues who filed some of these new H1B petitions that are subject to this $100,000 fee, which were accepted by USCIS based on the current fee schedule irrespective of the $100,000 fee. Now, the question we all have is, how will these cases be adjudicated, given that under the terms of this proclamation and the guidance, these cases are subject to it. So essentially, the bottom line is, as of this moment, October 2025, there is no guidance on how to even pay this fee. So for those, I assume, small amount of you out there who are even considering this, if you're considering paying the fee and you're wondering how to do it, simply don't know, because there has been no guidance. My expectation is that the government will continue to accept cases under the current fee schedule, but that the adjudication of these cases will very likely be delayed until there is proper guidance on how to pay the fee and who exactly has to pay the fee. So because of all of this, I am expecting legal challenges to the proclamation and the $100,000 fee. I think the main reason why there has been no litigation challenging it as of this moment is simply that because there's no mechanism to pay, nobody has actually paid the fee. And also because these rules are so recent, no H1B petition has been processed under this new proclamation. So essentially, there's nobody who has been injured by it yet. So unless you have an injured party, you can't bring a lawsuit based on that injury. But I am expecting lawsuits challenging the president's authority to impose the fee, the rationale behind the fee, as well as how these rules will be implemented in practice. To provide a bit more detail, I think the main challenges and the main arguments challenging this $100,000 fee will be, first, that the president exceeded his authority because the Immigration and Nationality Act grants Congress, and to a limited extent federal agencies, the authority to impose fees. But it does not allow and provide authority for the president through a proclamation to impose such a fee. Similar to this argument, I foresee arguments about the fact that there was no notice and comment period, which the Administrative Procedure Act requires that federal agencies have this notice and comment period in their rulemaking process. So whenever these agencies like USCIS change their rules, there has to be a notice and comment period provided, and that was not done here. But the fee itself will be collected by these agencies. Another challenge I foresee is essentially an argument that this fee is punitive, right? It's a punishment, or can be seen as a punishment, to those employers who are looking to hire H1B workers. So I think we'll see arguments challenging that. And then finally, I think there's going to be some due process and equal protection claims. And the arguments there are going to focus, I think, much more on this national interest exemption. And like I said, I'm predicting that the agencies will not be applying it consistently. And I think because it's going to be inconsistent, it's going to treat essentially some individuals better than others, and that's what's going to give rise to those claims. Now, I don't know at this point, because at this point there is no litigation, but these are the arguments I am foreseeing. Now, so here are some practical takeaways and considerations that I think everyone should keep in mind. So, like I said, I'm anticipating litigation. I'm also anticipating more guidance from these agencies. And what that will mean is that everything we know about this rule right now is very likely to change. So if the courts rule that the president didn't have the authority to impose this fee, well, then it may go away altogether, right? Also, if there is much more guidance and clarity provided by the agencies, or the rule is narrowed down, well, then it may only apply to a certain subset of applicants, right? But the bottom line is we don't know, and that lack of knowledge at this moment creates a lot of uncertainty. So because of this, my main tips, or just general sort of guidance to everyone, is if you don't have to travel, right? So that's what I'm saying to all of my clients generally. If they don't have to travel internationally right now, then avoid it for a few months, maybe, if it's not necessary, because I am expecting confusion by both CBP officers as well as consular officers, right? Now, I will say if you've got a valid H-1B visa and you've never had issues crossing the border, I don't necessarily think you need to forego traveling, right? But I definitely think before traveling internationally, make sure you're checking with your immigration advisor, attorney, etc., just to make sure that you're aligned with both your employer and the lawyers and everyone involved in your case. If you have to apply for a new H-1B visa stamp, I think that's where it gets tougher, because I'm expecting consulates to be confused given how little guidance there was in the rollout of this rule, right? So essentially, I think there could be delays on H-1B visa issuance, even if it's an extension. Essentially, you filed an extension petition, it was approved, and now you need a new visa stamp. I could see delays. So again, I would minimize any unnecessary travel. If travel is necessary, again, just make sure you're working with your immigration team to make sure you're well prepared for any issues. Very similar to this advice, I've been telling all of my clients who do want to file some new H-1B petitions, but there's no urgency. In those cases, I'm cautioning everyone and just saying, let's wait a little until everything clears up, right? With the more guidance, litigation, etc., we may have a much clearer picture in a matter of weeks or months. And if the beneficiary is not expected to arrive in the U.S. for months in the future, well, then there may not be a need to file any petitions currently. Now, of course, what's going to get complicated here is that H-1B lottery, like cap subject petitions, generally have deadlines, right, by which they have to be filed. So if we don't have guidance come the new lottery season in 2026, well, then this advice is going to be very hard to implement in practice. But again, it's a bit of a wait and see approach. Another general takeaway here is that I think everyone needs to plan ahead. Irrespective of what happens here, this will cause delays at consulates. This will not make H-1B visa processing faster, right? So if you're planning to travel internationally and get an H-1B visa, make sure you're planning ahead. If your employer has signaled that they're going to be filing an extension for you, make sure you're planning ahead, right? Any H-1B petition, plan ahead and work with your immigration team and make sure you're providing all the necessary documents quickly so that they can move through it as fast as possible, because this will make H-1B processing more challenging, especially until we don't have clear guidance. Similarly to this tip, any F1 students or J1s and anyone in the US who is expecting that their employer will be filing an H-1B petition for them, work closely with your employer, right? It's going to be a lot of these new petitions, right, that are going to be impacted. Now, at this point, it seems like the change of status petitions are exempt, right? That they're not going to be, the rule isn't going to impact them, but work closely with your immigration team, because up until now, we had many people who preferred to do a consular case where they weren't doing a change of status and it was a new petition, and they would go and consular process the H-1B visa. Well, that is no longer going to work. If change of status petitions are going to be exempt from this $100,000 fee, but essentially consular processed initial H-1B petitions are going to be subject to it, well then to avoid the fee, I'm assuming that the guidance is going to be that those individuals should be filing change of status petitions. But again, make sure you're closely working with the attorneys and then the immigration team to make sure you have a good plan here. My final point on all of this, and this is just more of a general thoughts on it, my gut intuition is, and please don't hold me to this because I have no proof, but my intuition is, and I've seen several prominent immigration lawyers agree with this, is that this rule will be narrowed down to only apply to the industries it's looking to target. Essentially, those H-1B petitioners who've taken up an enormous amount of these H-1B petitions and whom the government views as taking advantage of this H-1B system and not really benefiting the U.S. But essentially, the government's argument is that they're bringing in these H-1B workers for positions for which companies could have hired U.S. workers. Now, again, I expect this to be messy. I think it's very difficult to narrow down a rule like this, but I think the final version of this rule is not going to be as broad as we see it today, but only time will tell. So the bottom line is be on top of it, follow this, and be diligent. And then on my end, I will do my best to record follow-up videos, provide guidance as I have it, as we receive more information or as there's more litigation and we're seeing how the courts are ruling on all of this. Thank you so much for watching this video and for tuning in again. And I really appreciate all of you. Thank you.